Hello, I'm Dr. Mark Leiser. I work on law, technology, and digital governance with a particular focus on how European digital regulation actually functions once it leaves the page and has to be used by institutions, regulators, companies, courts, and advisors. This lecture is part of a wider series I've been developing on the EU's digital rulebook, the GDPR, the AI Act, the Omnibus process, the digital fitness check, and the broader question of whether Europe's regulatory architecture is still coherent enough to guide conduct before disputes arise. The recurring theme in my lectures is fairly simple. Rights need structure. They need legal certainty, proportionality, and institutions capable of applying the law without turning every difficult technical question into a permanent crisis of scope. The immediate background to this lecture is the APEP-IA conference in Madrid, where I was asked to join a panel on AI from a European data protection perspective. The panel brought together three different viewpoints: institutional enforcement, industry compliance, and my own focus on the need for legal certainty and appropriate governance across the wider digital acquis. These questions are not small ones. They asked whether foundational concepts from the GDPR like personal data under Article 4 and automated decision-making under Article 22 still have enough certainty in the new type of inference economy in which we're living. They ask whether the AI Act can really be operationalized when standards and guidance arrive late, and even when the prohibited practices under Article 5 require a great deal of legal translation. They ask whether the Omnibus and digital fitness check should be seen as a weakening of rights or as a necessary attempt to make the digital rulebook work as a system. And they ask what happens to privacy professionals when the field expands into AI, consumer protection, discrimination, platform governance, institutional design, and fundamental rights more generally. In Madrid, those questions, and every conference really, those questions have to be answered in a panel format, which means short interventions, compressed arguments, and even very little time to unpack the legal architecture behind them, let alone answer questions from the audience. That is why I thought it was worth turning my answers into a fuller online lecture. The issues deserve more than a few conference soundbites. They matter for DPAs, academics, lawyers, policymakers, companies, and civil society, because they go to the heart of whether European digital regulation is becoming more effective or simply more procedurally dense. So this lecture is not really about whether we should be for or against the GDPR or for or against the AI Act. That's just simply too crude. The better question is whether the system we have built can tell serious actors what to do. Can it distinguish exploitative data use from necessary safeguard-based data use? Can it protect fundamental rights without treating uncertainty as a virtue? Can it support innovation without reducing legal certainty to an afterthought? That is the frame for what follows. My argument is that the problem is not old law versus new technology, it's stable law versus expanding uncertainty. So that for me is the real question that came out of my Madrid experience. Not whether privacy professionals can learn another regulation, not whether we can bolt the AI Act onto the GDPR and call the result a digital rulebook. The harder question is whether the legal architecture Europe has built can still tell serious actors what to do before the deadline arrives, before enforcement positions harden, and before guidance becomes the law in practice. I'm not going to argue that the GDPR is obsolete. That's too easy. And I'm not going to argue that the AI Act is wrong simply because it's complicated. Serious technologies require serious law. The issue is whether our legal concepts are stable enough, our institutions coordinated enough, and our compliance pathway is proportionate enough to protect rights in this new economy. That phrase matters. We're not only dealing with databases. We are dealing with systems that infer, classify, rank, recommend, predict, prioritize, personalize, exclude, nudge, optimize, and shape environments. Some make formal decisions. Many do not. But they can still decide what a person sees, what products and services they are offered, what they are denied, whether they are escalated, and whether they are treated with suspicion. So the Madrid panel questions that we were asked are not really separate compliance puzzles. They are a test of legal architecture. Article 4 of the GDPR asks whether the personal data threshold still provides a stable trigger. Article 22 asks whether the law still captures the meaningful exercise of automated power. Article 5 of the AI Act asks whether prohibitions can be implemented as law. Article 10.5 of the AI Act asks whether data protection and non-discrimination can be reconciled in practice. And the final question asks whether we are still privacy professionals or have become something broader. My answer is this: rights need architecture. They need clear triggers, disciplined thresholds, proportionate pathways, and institutions that know which legal instrument is supposed to do which job. More procedure is not always more protection. More ambiguity is not more rights. And a law that becomes too elastic, too late, and too difficult to foresee does not become stronger. It becomes less governable. My Madrid panel questions look separate, but they're really connected by a single concern: whether the digital rulebook can still guide conduct. That word guide is important. Law does more than punish after the fact. It should organize behavior in advance. It should tell a public authority, a developer, a deployer, a researcher, a DPA, a lawyer, and a court which legal category they fall into and what follows from that category. Article 4 of the GDPR asks the first question: are we dealing with personal data? If the answer to that is yes, a full architecture of rights and obligations is triggered. If no, the GDPR does not disappear as a normative influence, but its legal machinery is not engaged in the same way. That threshold is supposed to matter. Article 22 asks the second question: has the person been subject to a decision based solely on automated processing that produces legal or similarly significant effects? That protection matters, but it is built around a relatively identifiable decision as a relatively identifiable point. Article 5 of the AI Act asks a third question: are some AI practices so incompatible with union values and fundamental rights that they should be prohibited altogether? That's a powerful move, but a prohibition only works if the concepts inside it can be used. Manipulation, deception, vulnerability, material distortion, appreciable impairment, and significant harm are not self-executing words. Article 10.5 asks a fourth question: can we identify and correct bias in high-risk AI systems without creating an impossible conflict with the caution that data protection law rightly applies to special categories of personal data? Put those together, and the real question becomes this: does the EU digital acquis function as a system? My concern is that too often it does not. We have individually defensible instruments that, when layered together, generate cumulative burdens, threshold uncertainty, duplicated assessments, and unresolved contradictions. The GDPR may be defensible. The AI Act may be defensible. Consumer law, platform law, data access law, equality law may each be defensible. But systems fail not only because individual parts are bad, they also fail because individually rational parts do not fit together. That is why I keep returning to legal certainty, proportionality, and institutional balance. These are not slogans. They are the conditions under which fundamental rights become usable law rather than noble pressure points. So let's start with Article 4 of the GDPR, because everything else depends on it. Article 4.1 defines personal data as any information relating to an identified or identifiable natural person. That definition is intentionally broad. It has to be. The GDPR was not designed to protect only names, addresses, passport numbers, and obviously intimate information. It was designed to protect people in a technological environment in which identification can be direct or indirect. But breadth is not boundlessness. The discipline comes from identifiability, and Recital 26 of the GDPR explains how to think about it. It does not say that every theoretical possibility of identification is enough. It says we should take into account the means reasonably likely to be used, either by the controller or by another person, to identify the natural person directly or indirectly. It also asks us to consider objective factors like cost, time, the available technology and technological developments. That language matters. It's not metaphysical. It is a contextual, actor-sensitive test. It asks what is realistically likely in the processing environment, not what a sufficiently creative lawyer can imagine. In AI context, that threshold has become unstable. Synonymization, model training, singling out, inference, downstream linkage, dataset enrichment, and data sharing all put pressure on the boundary. Some of that pressure is real. Inference can be powerful. Linkage can be foreseeable. Synonymization can be weak. A dataset that looks remote from identity in one context can become even revealing in another. But the answer can't be to abandon the discipline of the threshold. If every possible inference is enough, and every theoretical relinkage is enough, personal data stops being a threshold and becomes a gravitational field. Everything nearly is pulled in. Everything nearby is pulled in. That may sound protective, but it's not legal certainty. It is perimeter panic. The best position is not that synonymized data is always outside the GDPR. Plainly, it's not. Nor is it that synonymized data is always personal data to everyone in every context. The better position is that the same legal test must take factual position seriously. Who has the key? Who has access to supplementary data? What technical and organizational controls are in place? What legal or contractual barriers prevent relinkage? What enrichment or disclosure routes are reasonably likely, not merely imaginable? This is why the SRB litigation against the European Data Protection Supervisor matters for the debate. Not because it solves every question, but because it reinforces the importance of realistic identifiability. The same data may be personal data for one actor and not for another, depending on whether that actor has realistic means of identifying the person. That is not fragmentation. That's a common legal test applied to different factual positions. For AI development, that's not a doctrinal curiosity. Before an organization can decide on lawful bases, transparency, minimization, DPIAs, data subject rights, data sharing, bias testing, research governance, retention, and model evaluation, it must determine whether the GDPR is triggered at all, and for whom. If that determination cannot be made with sufficient confidence, compliance becomes defensive over-inclusion. Defensive over-inclusion is not harmless. It deters research. It burdens smaller actors. It pushes projects into legal review rather than technical risk reduction, and gives institutions perimeter setting power after the fact. So my Article 4 point is simple. Keep the definition broad where identification is realistic, foreseeable, and actor relevant. But do not pretend that abstract possibility is the same as realistic identification or identifiability. If the law's trigger becomes unpredictable, the law stops guiding conduct. And Article 22 presents a different problem. It gives the data subject the right not to be subject to a decision based solely on automated processing, including profiling, where that decision produces legal effects or similarly significant effects. It includes exceptions and it requires safeguards, such as human intervention, the opportunity to express a point of view, and the ability to contest the decision. That's a serious provision. I do not dismiss it, but it's built around a particular structure, a decision based solely on automation, having legal or similarly significant effects. In many AI systems, the exercise of power does not wait for that neat legal moment. Think about ranking, recommender systems, fraud scoring, employment screening, educational allocation tools, insurance risk categorization, public sector triage, content visibility, vulnerability targeting, behavioral nudging, and dynamic pricing. In each context, the system may not make the final formal decision, yet it may organize the options available to the person. It may determine what is visible, what is probable, what is offered, what is delayed, what is escalated, or what is scrutinized. The law then risks asking the wrong question at the wrong time. It asks, was there a solely automated decision producing legal or similarly significant effects? But the more important question may be, how has the system already structured the person's environment before any formal decision appeared? That's why Article 22 often looks too late in the chain. AI power frequently operates upstream. It's not only the refusal of a loan, it's the rank ordering that determines whether an application is reviewed with suspicion. It's not only the denial of a benefit, it is the scoring system that places one person in a queue and another in the fast lane. It's not only the final content decision, it's the recommender architecture that constructs the informational environment within which the person acts. That does not mean Article 22 is useless. It means Article 22 should not be asked to do all the work. Some harms are better addressed through fairness, transparency, purpose limitation, data protection by design and default, DPIAs, contestability, consumer protection, equality law, sectoral rules, and AI Act obligations for high-risk systems. So if we stretch Article 22 to encompass every upstream influence, we lose the provision's shape. If we leave upstream influence unaddressed because it does not fit Article 22, we miss the governance problem. The mature approach is to recognize the mismatch. Article 22 was designed for decisions. The inference economy often works through architectures of influence. Those architectures can be legally relevant, but they require a broader mix of instruments rather than a forced reading of a single provision. For DPAs, this creates a strategic challenge. It's tempting to expand the familiar tool. The GDPR is known, DPAs have powers. There is a mature enforcement culture. But familiarity is not the same as fit. So I would put the Article 22 point like this. Keep it, but stop pretending it's a complete theory of automated power. We're no longer only dealing with decisions. We're dealing with architectures of inference and influence. So I want to pause on legal certainty for a second, because it's often treated as merely an industry demand. That is a mistake. Legal certainty is a rule of law value. It is about foreseeability, non-arbitrariness, democratic perimeter setting, and institutional restraint. It's about ensuring that obligations are not expanded mainly through soft law, enforcement preference, institutional mood, or interpretive drift. It's also about ensuring that the protection of rights does not depend on ambiguity. A rights protective framework still has to be foreseeable. It must allow actors to understand in advance when the law applies, what obligations follow, what conduct is prohibited, what safeguards are required, and how authorities are likely to assess the conduct. The law cannot answer every question in advance, but the core architecture must be knowable before enforcement. This matters not only for the industry. It matters for researchers, universities, public bodies, SMEs, startups, civil society organizations, and DPAs themselves. A supervisory authority cannot build a stable enforcement strategy on concepts that are permanently elastic. Uncertainty has distributional effects. Large actors can survive that ambiguity. They can hire lawyers, lobby for guidance, absorb delay, and turn uncertainty into a strategic asset. Smaller actors can't do that. A research team, civil tech organization, university lab, or SME cannot live indefinitely in a world where every threshold question requires a memorandum, a risk committee, and 3 conflicting interpretations of guidance. So when we say legal certainty, we should not hear deregulation. We should hear institutional discipline. This is especially important because the GDPR is no longer a self-contained instrument. It is a hinge. Once something is personal data, implications extend across AI governance. Research, platform regulation, data access, consumer interfaces, advertising, public sector systems, and bias mitigation. If the GDPR perimeter is unstable, other regimes become unstable around it. The same is true for the AI Act. If the real meaning of a prohibited practice, high-risk obligation, conformity requirement, or data governance duty is only settled after late guidance, then the law is not giving enough ex-ante direction. It may still be enforceable, but enforceability is not governability. Legal certainty is not the enemy of rights. It's one of the conditions under which rights become real. The point is not lower protection. The point is protection that can be used. Now, this brings me to Article 5 of the AI Act. Now, I worked directly on the prohibited practices questions, preparing background reports for the Commission on Article 5(1)A and B, subliminal, manipulative, and deceptive techniques, and AI systems that exploit vulnerabilities. That work made the legal problem concrete. At a high level, the consensus is easy. Nobody wants AI systems that deploy genuinely subliminal techniques to undermine autonomy. Nobody wants systems that deliberately exploit children, persons with disabilities, or people in acute social or economic vulnerability. And nobody wants AI-enabled practices that materially distorts behavior and causes significant harm. At that level, the politics and the ethos of the Act's provisions are pretty straightforward. The difficulty begins when the prohibition must become law in the operational sense. What counts as a purposefully manipulative technique? How is deception different from ordinary persuasion, poor interface design, or aggressive advertising? What does it mean to appreciably impair a person's ability to make an informed decision? What amounts to a material distortion of behavior? What counts as significant harm? How likely must the harm be? Must the system be targeted at a vulnerability? Or is it enough that vulnerable persons are foreseeably affected? How do we treat recommender systems, dark patterns, behavioral advertising, synthetic media, and hyper-personalized nudging? These are not academic questions. They are the questions that determine whether the prohibition is usable. A prohibition is a special kind of legal instrument. It does not merely impose a process. It marks a boundary beyond which the practice is not allowed. That boundary must be strong enough to protect fundamental rights, but precise enough for developers, deployers, advisors, regulators, courts, and effective persons to understand. If the boundary is too narrow, serious harm escapes. But if it is too wide, ordinary design choices, legitimate persuasion, beneficial personalization, and protective interventions become legally suspect. If it's too vague, the real boundary is set not by legislation, but by subsequent guidance and enforcement. During my Article 5 work, what struck me was the difference between agreement on an example and an agreement on a principle. A case study could look persuasive. One could look at it and say, yes, this practice looks like the kind of thing Article 5 is aimed at. But once you try to extract the principle and apply it to a neighboring case, hesitation appeared. That hesitation was revealing. It suggested that the normative instinct was strong, but the operational theory was less subtle. And in law, the operational theory is not a detail. It is the law. So the AI Act cannot function only as a collection of moral intuitions. It has to become a usable grammar for governance. And this leads to what I call the burden of translation. Europe has often legislated in a digital field at a high level of abstraction and then relied on guidance, standards, common specifications, institutional coordination, enforcement practices, and eventually litigation to fill in the operational details. Some of that is unavoidable. Complex technologies cannot be governed through slogans, and legislation cannot anticipate every system design or business model. But timing matters. If the real meaning of the law becomes clear only after 100 pages of guidance, after standards that are later incomplete, after interpretive disputes among authorities, and after compliance deadlines are approaching, then the law has not done enough work before it begins to bite. Late clarity is not clarity. For the actor subject to the law, late clarity is remediation, rework, delay, defensive redesign, legal spend, and uncertainty about whether a product, research product, or public sector tool should proceed. The Article 5 guidelines are a good illustration. They are useful. They provide legal explanation and practical examples. They help support more uniform application of the prohibitions. But for the very need for that level of explanation tells us something about the design of the instrument. If a core prohibition requires substantial secondary work before sophisticated actors can understand its contours, the system is carrying a heavy translation burden. And that burden is not only on companies. It falls on the Commission, the AI Office, market surveillance authorities, DPAs, and other fundamental rights authorities, national courts, advisors, academics, and standardization bodies. Everyone is asked to help construct the usable meaning of the regime after the legislation has already been adopted. That model has costs. It can produce institutional drift where guidance becomes the real law despite lacking the democratic status of legislation. It can provide even uneven enforcement. It can produce compliance theater where organizations produce documentation that tracks guidance language but does not reduce real risk. And it can create strategic uncertainty where large actors wait and adapt while smaller actors withdraw or never enter. So when I say the AI Act cannot self-execute, I do not mean it is worthless. I mean its ambitions depend on a large ecosystem of secondary translation. The question is whether that ecosystem can deliver clarity early enough, consistently enough, and proportionately enough to support both rights, protection, and innovation. A rights-based system cannot depend on everyone guessing the grammar of the law until guidance arrives. There is a common pattern in AI governance debates. A vivid example is presented. The example is disturbing. It shows an exploitative interface, a manipulative recommender system, a behavioral nudge aimed at a vulnerable person, or a predictive tool that leads to unfair treatment. However, everyone agrees the example is bad. Then the example is treated as if it proves the broader principle. But it does not always do that. Agreement on the example is not agreement on the principle. A principle must travel. It must work in adjacent cases. It must distinguish between the abusive and the acceptable. It must avoid both under-inclusion and over-inclusion. It must be usable by someone who was not in the room when the example was discussed. That is the legal calibration problem. Take manipulation. If manipulation means any influence on behavior, the concept becomes useless because much of law, education, public health, advertising, and interface design influences behavior. If manipulation means only hidden coercion, the concept may be too narrow and miss many forms of AI-enabled behavioral exploitation. The law needs a middle category. It needs to identify when influence becomes autonomy undermining in a way that justifies a prohibition. Take vulnerability. If vulnerability is too narrow, the law protects only obvious cases. If it's too broad, every consumer, child, worker, patient, debtor, platform user, and perhaps every person in an asymmetrical digital environment becomes vulnerable for the purposes of a prohibition. That might sound attractive, but it would make the threshold unstable. Take harm. If harm must be proven with certainty after the fact, the prohibition may be too weak. If harm is merely speculative, it may be too wide. The AI Act's language of harm that is caused or reasonably likely to be caused requires judgment, seriousness, probability, and a causal connection. This is where high-level AI ethics discourse often becomes inadequate. It is good at identifying troubling practices. It's much less good at drawing legal thresholds. But regulation lives in thresholds. For regulators, this matters because enforcement must be more than a moral reaction. It must be justified in legal terms. For academics, it matters because the theoretical concern is not doctrinal sufficiency. For the industry, it matters because compliance requires more than being told to avoid bad practices. The Article 5 lesson is this: powerful examples are necessary, but not enough. We need principles that travel without becoming reckless. The law cannot be a museum of bad examples. It must be a discipline of usable distinctions. This is why I see the Omnibus and the digital fitness check as more than technical housekeeping. The debate has often been framed as a choice between simplification and rights protection. I do not accept that framing. It assumes that procedural density equals protection, and that any reduction in procedural burden must therefore weaken rights. That is wrong. In a complex regulatory system, excessive procedure can make substantive protection harder. It can obscure priorities, multiply documentation without improving accountability, push organizations towards formal compliance rather than risk reduction, overwhelm regulators with paperwork, create contradictions between instruments, and reward actors with the resources to manage complexity. The better question is whether the digital acquis works as a system. The GDPR, the AI Act, the Digital Services Act, the Digital Markets Act, the Data Act, consumer law, cybersecurity law, sectoral safety rules, equality law, and public administration law all operate in overlapping spaces. Each must be justified in isolation. But legal systems are not experienced in isolation. They are experienced cumulatively by those who build, deploy, challenge, regulate, and are affected by digital systems. When these regimes are poorly aligned, three things happen. First, we get into threshold fights. Is this personal data? Is this high-risk AI? Is this profiling? Is this a dark pattern? Is this discrimination? The classification exercise becomes a battleground. Second, we get duplicated procedures, multiple impact assessments, multiple records, multiple notices, multiple committees, multiple reporting obligations. Some duplication may be necessary, but not all duplication is protection. Third, we get institutional imbalance. If every digital question is pulled into the GDPR, DPAs become de facto general digital regulators. If every AI question is pushed into the AI Act without regards to data protection, equality, consumer law, or sectoral safety, AI governance becomes artificially narrow. If soft law fills too many gaps, the perimeter shifts away from legislation. That is why the Omnibus is a constitutional moment in the broader sense. It asks how the union's digital rulebook allocates legal responsibility across instruments and institutions. It asks whether we have coherent architecture or merely accumulation. The serious question is not simplification versus fundamental rights. It's contradiction versus coherence. Article 10.5 of the AI Act exposes this contradiction better than almost any other provision. Article 10 deals with data and data governance for high-risk AI systems. It requires attention to training, validation, and testing data. It requires examination of possible biases that are likely to affect health and safety, have a negative impact on fundamental rights, or lead to discrimination prohibited under union law. It also requires an appropriate measures to detect, prevent, and mitigate those biases. Then Article 10.5 acknowledges the hard part. To the extent strictly necessary for bias detection and correction, providers of high-risk AI systems may exceptionally process special categories of personal data subject to safeguards. That is a very important recognition. If we're serious about non-discrimination in AI systems, we have to be honest about what bias testing sometimes requires. You cannot always detect group-based discrimination without some lawful way of examining outcomes across relevant protected or sensitive characteristics. If you cannot see whether a system treats groups differently, you may not know whether it is discriminatory. If you cannot know, you cannot correct. And if you cannot correct, the rhetoric of fairness becomes empty. This is the uncomfortable point. The same legal system that rightly treats special category data with caution also demands that AI systems avoid discriminatory outcomes. Those commitments are not enemies, but they can collide if the law does not provide a clear route for necessary processing. Suppose a high-risk system is used in employment, education, credit, public benefits or healthcare triage. Suppose the provider or deployer needs to know whether the system produces systematically different error rates, exclusion rates, false positives, false negatives, or ranking outcomes for groups protected under a quality law. In many cases, that analysis may require data revealing racial or ethnic origin, health status, a disability, sex, or other sensitive characteristics. It may not always require collecting new special category data. Sometimes synthetic data, anonymized data, proxy analysis, external audits, or statistical methods may suffice. Article 10.5 rightly requires alternatives to be considered, but sometimes they will not suffice. And if the law says do not process such data, while also saying detect and mitigate bias, it creates an impossible position. It demands non-discrimination while disabling the means of detecting discrimination. That is not a mature right strategy. The better question is not whether special category data can be used casually. It should not. The better question is when such processing is strictly necessary, how it should be bounded, and what safeguards make it legitimate. Article 10.5 shifts the debate from procedural suspicion to structured necessity. It says, this is exceptional, this must be strictly necessary, this must be safeguarded, this must not be reused, this must be documented, this must be secured, and this must be deleted when the bias is corrected when the retention period ends, or when the retention period ends. That is not deregulation. It's a rights-based pathway for a difficult but necessary function. Article 10.5 is not just about datasets. It is a test of whether the EU Digital Rulebook can distinguish exploitative data use from necessary safeguard-based data use. If it cannot make that distinction, it will fail for both data protection and non-discrimination. The answer is not deregulation, it's smarter governance. In the Article 10.5 context, smarter governance begins with strict necessity, not convenience, not curiosity, not general product improvement. Strict necessity for bias detection and correction in relation to a high-risk AI system. Then comes substitution. Can the objective be achieved through other data, including synthetic or anonymized data? If yes, use those routes. If no, explain why. That's not box ticking. It's a disciplined proportionality inquiry. Then come safeguards, technical limitations on reuse, state-of-the-art security, privacy-preserving measures, pseudonymization where appropriate, access controls, documentation of access, confidentiality obligations, separation between teams where necessary, restrictions on award access, deletion once the bias is corrected or the retention period ends, and records explaining why the processing was strictly necessary and why other data would not work. Add to that the GDPR architecture, purpose limitation, data minimization, transparency where possible and appropriate, accountability, data protection by design and by default. DPIAs were required and prior consultation in high-risk residual cases. The point is not to bypass the GDPR. The point is to make the GDPR and the AI Act speak to one another. This is more demanding than procedural overload. Procedural overload often creates piles of documents without forcing the hard questions. Smarter governance asks them directly. What is the legitimate objective? What data is strictly necessary? What alternatives were considered? What risks arise? What safeguards reduce those risks? Who can access the data? How long is it kept? How is misuse prevented? How is the analysis audited? Who is accountable? Proportionality is central here. In European Union law, proportionality is not a concession to business. It's a methods of rights reasoning. It asks whether a measure is suitable, necessary, and balanced. It prevents both under-regulation and overreach. Data protection and non-discrimination are not competitors in a zero-sum game. They are both part of the rights architecture. The legal task is to reconcile them without pretending that one always defeats the other. Uncertainty is not a safeguard. Refusal to balance is not rights protection. Procedure is not a substitute for judgment. Smarter governance is not weaker governance. It is governance that knows what it is trying to achieve. The final question asked in my Madrid panel is personal. Are the people in the room still privacy professionals, or have they become something broader? And I think we've all become something broader, whether we like it or not. Privacy remains essential. Data protection law is one of the most important rights-based frameworks in the digital environment. But privacy is no longer the whole field, and it cannot be the default answer to every digital problem. Some problems are data protection problems. Some are equality problems. Some are consumer protection problems. Some are competition problems. Some belong to labor. Some are public sector accountability problems. Some are problems of safety. Some are cybersecurity. Some are media and democracy problems. Some are institutional design problems. Privacy and data may be somewhere in the story, but it's not always the right organizing frame. That shift has changed the profession. It has also made me more skeptical about some habits in academia and professional training. In teaching, we've often trained students to see digital systems through privacy goggles. That has produced real expertise, but it's incomplete. If every digital harm is translated into GDPR language, the analysis becomes distorted. A discriminatory hiring system is not only a personal data problem, a manipulative online interface is not only a transparency problem or a fairness problem. A dominant platform's use of data is not only a lawful basis problem. A recommender system that affects democratic discourse is not only a profiling problem. The legal tool must fit the harm. In research, we have a related problem. Academic work is often excellent at identifying possible harms. That is useful, but it can become an incentive structure for risk inflation. The more novel the harm, the more urgent the article. What is often missing is a disciplined assessment of likelihood, seriousness, causation, and legal fit. Risk regulation is not a competition to imagine the darkest possible scenario. It is the work of matching real risks to proportionate interventions. The mature question is not merely what could go wrong, it is how likely is it? How serious would it be? Under what conditions would it materialize? What legal instrument is best placed to respond? And what would a proportionate remedy look like? This matters for DPAs as well. Under the AI Act, fundamental rights authorities, including DPAs in many contexts, gain new relevance in relation to high-risk AI systems. Article 77 gives certain authorities powers to access documentation and request technical testing through market surveillance authorities when necessary for their mandates. That pushes DPAs into a more networked governance model. That will require a different mindset. Coordination with market surveillance authorities, equality bodies, consumer authorities, sectoral regulators, and courts. It will require understanding when the GDPR is central and when it is adjacent. It will require the humility to say, this is a serious digital harm, but data protection law is not the only or the best response. So yes, we are digital governance professionals now. That's myself included, and you all in the room when listening to this. The professional test should be calibration, better diagnosis, better legal fit, better institutional design, and better proportionality. We do not need fewer concerns. We need better architecture. So what did I talk away from my conference appearance and panel participation from the APEP conference in Madrid? First, keep stable trigger concepts. Article 4 of the GDPR must remain broad enough to capture realistic identifiability, but disciplined enough to reject abstract speculation. Recital 26 is not decorative. It is the grammar of the threshold, means reasonably likely to be used, objective factors, available technology, costs, time, technological developments. Second, recognize upstream influence. Article 22 GDPR remains important, but it cannot be the whole theory of automated power. AI systems often influence people before a final decision appears. We need governance of ranking, scoring, recommendation, optimization, behavioral shaping, without pretending every influence is the same as a solely automated decision. Third, demand operational clarity. Article 5 of the AI Act shows that prohibitions do not self-execute. Manipulation, deception, vulnerability, material distortion, significant harm require legal thresholds that can be used before enforcement, not merely after guidance and litigation. Fourth, treat the Omnibus as a systemic governance question. The issue is not simplification versus rights. It is whether the entire digital acquis of the European Union functions coherently across the GDPR, AI governance, consumer law, platform law, data access, equality law, and institutional enforcement. Procedural overload is not a proxy for rights protection. Fifth, build lawful pathways for necessary processing. Article 10.5 of the AI Act is just one. It recognizes that bias detection may sometimes require tightly bounded processing of special category data. That is not a license to process sensitive data casually. It is a narrow, safeguard-based mechanism for reconciling data protection and non-discrimination. 6. Broaden the profession. Privacy professionals have become digital governance professionals. That does not mean abandoning privacy. It means knowing when privacy is central and when it's partial and when another legal instrument should carry the weight. And finally, reject the false comforts. Reject the cliche that the problem is simply old law versus new technology. Reject the idea that more procedure automatically means more protection. Reject the idea that ambiguity is a fundamental right strategy. Reject the habit of expanding familiar legal tools until they lose their shape. Reject context-free risk inflation. Strict law can be good law. Ambitious law can be good law. Rights-based law can be good law. But vague, late, cumulative, and institutionally confused law is not made better because it is rhetorically protective. The law is not strengthened by becoming harder to foresee, harder to discipline, and easier to stretch. Rights need realism, and law needs discipline. Let me close with the line I want people to remember. The future of privacy work is not simply privacy. It is digital governance. The difficult work of matching legal tools to real harms across multiple regimes with enough institutional discipline to make rights effective. That requires resisting two temptations. The first is to treat AI as a reason to abandon the GDPR's core commitments. That would be a mistake. The GDPR still provides essential rights architecture, fairness, transparency, accountability, purpose limitation, security, data minimization, and individual rights. The second is to stretch those commitments until they lose their shape. If every inference is personal data for everyone, if every influence is an automated decision, if every clarification is a rights rollback, and if every difficult data use is treated as suspect regardless of necessity and safeguards, the system does not become more protective, it becomes less coherent. The EU's challenge is to avoid both mistakes. It must protect rights without turning uncertainty into a virtue. It must support innovation without treating legal clarity as deregulation. It must allow necessary safeguard-based data uses without opening the door to exploitation. It must give DPAs and other authorities real tools without making them permanent perimeter setters through ambiguity. It must make the digital acquis work as a system. Legal certainty matters not as an industry talking point, but as part of the rule of law and the fundamental rights architecture itself. If Europe wants trustworthy AI, lawful innovation, credible enforcement, and trusted institutions, the law has to do more than express concern. It has to guide conduct. It has to allocate responsibility. It has to set thresholds. It has to reconcile rights. And it has to be usable before the compliance deadline arrives. The problem is not old law versus new technology. It is stable law versus expanding uncertainty. Thank you for watching. The reports, my slides, Substack posts, LinkedIn discussion, you can access them all online on the links below. Bye-bye.